This week, the 9 justices of the United States Supreme Court are poised to make one of the most consequential economic decisions in decades. The ruling won't just be an abstract legal interpretation debated by scholars. It will have tangible, real-world effects that could reshape the American economic landscape for years to come. The decision carries the weight of precedent, potentially redefining the boundaries of presidential power in an era of global economic uncertainty. It's a moment where constitutional law intersects directly with the flow of commerce, and the outcome will be felt far beyond the marble halls of the court. A final ruling is expected as soon as Wednesday, January 14, 2026. This date marks the culmination of a months-long legal battle that has worked its way through the federal court system, creating significant uncertainty for businesses and consumers alike. As the day approaches, market analysts and corporate leaders are holding their breath, waiting for the clarity that only a Supreme Court decision can provide. The case centers on a very direct and powerful question. Did the president have the legal authority to unilaterally impose massive tariffs using an emergency law? Specifically, the court is examining the use of the International Emergency Economic Powers Act, or IEEPA. Enacted in 1977, IEEPA grants the president broad authority to regulate international commerce after declaring a national emergency in response to an unusual and extraordinary threat. Historically, it has been used to impose sanctions on foreign governments, terrorist groups, and individuals. The government argues that this flexibility is essential for a president to act decisively to protect national security and economic stability. However, the challengers, a coalition of importers, retailers, and business associations, contend that using IEEPA to enact sweeping tariffs across entire sectors of the economy is a vast overreach of executive power. They argue that the Constitution explicitly grants Congress the power to lay and collect taxes, duties, imposts, and excises. In their view, these tariffs function as a massive tax on American consumers and businesses, a power that belongs to the legislative branch, not the executive. The court's decision will therefore serve as a critical test of the separation of powers. At the heart of this case are the Liberation Day tariffs, which were enacted in April of 2025. These weren't small, targeted adjustments to trade policy. They were a seismic shock to the system of global trade that the U.S. economy relies on. Overnight, they dramatically increased the cost of importing a vast array of products, sending ripples down the entire supply chain. To put this into perspective, before these measures were implemented, the average U.S. tariff rate on imported goods was a relatively low 2.5%. The Liberation Day tariffs caused that average to skyrocket to about 15%. But the aggregate numbers don't even tell the full story. For certain categories of goods, the increases were far more extreme, with new duties reaching as high as 50%. Sectors like consumer electronics, clothing and apparel, automotive parts, and home furniture were all hit by a sudden and severe price shock. These are not luxury items. They are staples of modern life for millions of American households. The answer the Supreme Court provides will directly impact the prices you pay for these everyday goods. If the tariffs are upheld, the higher costs that importers have been paying will likely become a permanent feature of the U.S. market, keeping consumer prices elevated. If they are struck down, it could trigger a wave of price reductions as billions of dollars in duties are refunded and future costs fall. The ruling will also determine the health of thousands of American businesses. For nearly a year, small and medium-sized enterprises have been squeezed. They've faced an impossible choice: absorb the massive new costs and watch their profit margins evaporate, or pass the costs on to their customers and risk losing business. Many have been operating on razor-thin margins, and this legal battle will decide whether they get a crucial lifeline or are pushed closer to the brink. And that, in turn, affects the job market. When businesses face intense financial pressure, they often respond by freezing hiring, reducing hours, or, in the worst-case scenarios, laying off employees. The court's decision could either alleviate that pressure, potentially spurring job growth, or intensify it, creating headwinds for American workers. This isn't just a complicated legal battle for lawyers to debate. It is a pivotal economic event with the power to send powerful ripples straight to your bank account, the financial markets, and the U.S. economy for years to come. The stakes could not be higher. In the intricate world of global trade and finance, certain dates become focal points, moments when years of legal wrangling and economic uncertainty converge. Wednesday, January 14, 2026, has become one such date. All eyes in the financial world, from Wall Street trading floors to the boardrooms of small and medium-sized enterprises, are fixed on the Court of International Trade. This isn't just another day on the calendar. It represents a potential turning point for American commerce. The court has signaled that this is its next designated opinion day, a formal session where rulings on pending cases are released to the public. While there's never an absolute guarantee which decisions will be handed down, a powerful consensus has formed among legal experts and market watchers. They widely expect the landmark tariff case, which challenges the legality of Section 301 tariffs imposed on hundreds of billions of dollars of goods from China, to be among the opinions released. This expectation has transformed the day from a procedural formality into a high-stakes economic event. The anticipation is immense, palpable across entire sectors of the economy. This is because the outcome has been shrouded in profound uncertainty for so long, years, in fact. The legal battle has been a protracted affair, winding its way through complex administrative and judicial channels. Businesses, investors, and consumers have been caught in the crossfire, grappling with a trade policy whose final legal standing has remained a persistent question mark. For the companies on the front lines, the importers, manufacturers, and retailers, the period has been one of operational limbo. They have been forced to operate in a fog, unable to plan with any degree of confidence. Key strategic decisions have been put on hold. Do you absorb the tariff costs and accept lower margins? Do you pass them on to customers and risk losing market share? Or do you undertake the costly and disruptive process of reconfiguring your entire supply chain? Without a final ruling, every choice has been a gamble. Now, two fundamental questions hang in the balance, each with multi-billion-dollar implications. First, will supply costs for thousands of products, from consumer electronics to industrial components, suddenly drop? A ruling that invalidates the tariffs could effectively erase these duties overnight, providing immediate relief to importers and, potentially, downstream consumers. Second, and perhaps more dramatically, will massive refunds arrive? Since the tariffs were first implemented, companies have paid billions of dollars in duties that are now being legally contested. If the court rules against the government, it would trigger a colossal refund process for all tariffs paid on entries that were part of the lawsuit. We're talking about a potential capital injection into the U.S. economy measured in the tens of billions of dollars. This prolonged uncertainty has acted as a powerful brake on the economy. The chilling effect on business investment has been significant. Why build a new factory or upgrade equipment when your core cost structure could change overnight? This hesitation has also dragged on hiring. Companies have been reluctant to expand their workforce, fearing that a negative outcome could force them into painful layoffs. Strategic planning has been reduced to short-term contingency modeling rather than long-term growth initiatives. Adding a new layer of complexity and urgency to this scenario, U.S. Customs and Border Protection, the agency responsible for collecting tariffs and issuing refunds, recently announced critical changes to its payment processes. This isn't a theoretical update. It's a practical, operational shift that directly impacts how companies would receive any potential refunds from this case. Specifically, the agency has set a hard deadline. As of February 6th, just a few weeks after the potential court decision, the agency will permanently stop issuing paper checks for tariff refunds. It is moving exclusively to electronic refunds processed through the Automated Clearinghouse, or ACH, network. This is the same system used for direct deposits and automatic bill payments. This administrative change creates a crucial operational challenge. If the court rules against the tariffs on January 14th, companies will have just 3 weeks to navigate the government's portal and ensure their ACH information is correctly registered and verified. For large corporations with dedicated treasury departments, this may be a routine task. But for thousands of smaller importers, it could be a frantic scramble. Failure to enroll in time won't mean they forfeit the money, but it could lead to significant delays in receiving a refund that they have been counting on for years. That tight operational deadline adds a very real urgency to the situation. It transforms the court's legal decision into an immediate call to action for finance and logistics departments across the country. The window is unforgiving, and the pressure to prepare is mounting. The tension was already high, but a recent delay in the court's opinion schedule, which pushed the likely decision date to this week, only heightened the suspense. That brief postponement, however, had a silver lining. It gave importers, investors, and government agencies a few more precious days to brace for the potential shockwaves and finalize their response plans. Now, there are no more delays. The countdown to Wednesday is more than just waiting for a legal verdict. It's a countdown to a major economic event with the power to reshape supply chains, unlock billions in capital, and define the trajectory of American trade policy for years to come. At the heart of the nationwide debate over sweeping new tariffs lies a legal question that is, in principle, straightforward, even if its real-world consequences are profoundly complex. The entire controversy hinges on the interpretation of a single, powerful, and now highly contentious federal law. The Supreme Court's eventual ruling will not only determine the fate of billions of dollars in commerce, but could fundamentally reshape the balance of power between the President and Congress for generations to come. The core issue is whether a law designed for national emergencies can be used as a tool for broad economic policy. A question that forces us to look back at the original intent of our lawmakers and the historical limits of executive authority. The central legal question is this: does the International Emergency Economic Powers Act of 1977, commonly known as IEEPA, grant the President the authority to unilaterally impose sweeping tariffs on all imports from a specific country, or even globally? This law gives the President the power to regulate a wide range of economic transactions after declaring a national emergency in response to an unusual and extraordinary threat that originates substantially outside the United States. The key dispute is whether this broad regulatory power includes the ability to set import taxes, a power the Constitution explicitly grants to Congress. To understand the controversy, we have to look at why IEEPA was created. Enacted in 1977, it replaced the older and even broader Trading with the Enemy Act of 1917. IEEPA was designed to provide a framework for the President to respond swiftly to foreign crises that threaten the national security, foreign policy, or economy of the United States. Historically, its use has been clear and targeted. Presidents have invoked it to freeze the assets of terrorists, impose sanctions on rogue states like North Korea and Iran, and block transactions with foreign nationals engaged in cyber attacks or human rights abuses. It has been a scalpel for foreign policy, not a sledgehammer for domestic economic management. In this case, however, the administration invoked the law in a novel way. It declared that large, persistent trade deficits and what it termed unfair trade practices by other nations constituted an unusual and extraordinary threat to America's national security and economic stability. The argument posits that the erosion of the domestic manufacturing base, fueled by these trade imbalances, weakens the country's ability to produce critical goods, thereby creating a vulnerability. Based on this national emergency declaration, the administration claimed the authority under IEEPA to take immediate, forceful action. The chosen action was the imposition of a broad, flat-rate tariff on nearly all imported goods, justifying it as a necessary measure to compel other countries to change their practices and to protect domestic industries from what it described as an existential threat. This interpretation clashes directly with over 2 centuries of American legal tradition. The Constitution, in Article 1, Section 8, explicitly gives Congress the power to lay and collect taxes, duties, imposts, and excises, and to regulate commerce with foreign nations. Historically, Congress has fiercely guarded this authority. While it has at times delegated some of that power to the executive branch, it has always done so through specific trade legislation, such as the Trade Act of 1974, which lays out clear procedures, criteria, and limits for any presidential action on trade. Critics, including a broad coalition of business groups, importers, and legal scholars, argue that the president fundamentally overstepped his authority. Their argument is twofold. First, they contend that a trade deficit, which is a simple macroeconomic metric, does not qualify as the kind of unusual and extraordinary threat IEEPA was meant to address. Second, and more critically, they argue that the administration sidestepped the specific laws Congress created for trade disputes, opting instead to use a broad emergency law that was never intended for setting general-purpose tariffs. Their legal reasoning is grounded in a principle of statutory interpretation. If Congress had intended for IEEPA to grant the president the monumental power to rewrite the entire U.S. tariff schedule, they argue it would have said so explicitly and unambiguously. Instead, the law is silent on tariffs, while numerous other statutes address them in painstaking detail. This, they claim, is a classic case of the executive branch trying to find an elephant in a mouse hole. This very tension was on full display during oral arguments before the Supreme Court on November 5, 2025. Observers noted that justices from across the ideological spectrum appeared deeply skeptical of the administration's expansive reading of its own power. Both conservative and liberal justices pressed the administration's lawyers hard on the potential limits, or lack thereof, of their theory. One justice reportedly asked, "If a trade deficit is an emergency, what isn't? Could a president declare an emergency over climate change and use this law to ban all fossil fuel imports?" Another questioned whether accepting the administration's argument would effectively render Congress's constitutional power over commerce meaningless, allowing any president to bypass the legislative branch on economic policy by simply uttering the magic words, "national emergency." The justices repeatedly probed whether chronic economic conditions like trade deficits, which have existed for decades under various administrations, could logically meet the law's definition of an unusual and extraordinary threat, requiring immediate emergency action. The questioning suggested the court was struggling to see how a persistent feature of the global economy could be treated like a sudden foreign attack or the discovery of a terrorist financing network. Based on the tenor of these arguments, most court analysts and legal experts predict that the court is likely to strike down the tariffs, probably on the grounds that the executive branch exceeded the authority granted by the statute. However, nothing is final until the formal opinion is released, and the court could still issue a narrower ruling or surprise observers entirely. The implications of this decision will extend far beyond the immediate case and the current administration. If the court were to uphold the action, it would dramatically expand executive power over the economy. It could empower future presidents to bypass Congress on a host of issues by declaring emergencies, effectively creating new economic policy by decree. This would set a powerful precedent, making IEPA a go-to tool for any administration seeking to implement its agenda without legislative approval. Conversely, striking down the tariffs would serve as a powerful reaffirmation of Congress's central role in regulating foreign commerce. It would clarify that broad emergency laws are not catch-all solutions for complex, long-term economic problems. Such a ruling would send a clear signal that for major economic shifts like tariffs, the president must work through the legislative channels established by the Constitution, preserving the delicate separation of powers that underpins the American system of government. If the court rules the tariffs were imposed illegally, those duties would end. The 10 to 50% taxes on a wide range of imports would be lifted. For companies relying on imported parts or finished goods, costs would fall almost overnight, boosting financial health. Retailers, manufacturers, and tech firms could see an immediate landscape shift after a year of extra costs. Next comes a flood of refunds. The government would return duties collected. Estimates peg potential refunds at about $150 billion. Over 1,000 companies, including household names, have filed to preserve their claims. That cash could be used to invest, hire, or lower prices. Trade flows could normalize as firms reassess sourcing. Some will revert to more efficient pre-tariff supply chains. Others will find new opportunities. Stocks in import-heavy sectors would likely rally as uncertainty lifts. The most tangible consequence would be the massive refund process. Over 1,000 companies filed protective lawsuits to secure repayment rights. From multinationals to small family importers, the impact spans the economy. If the court rules against the tariffs, the government must repay duties collected. The estimated total is about $150 billion. This isn't abstract. It could transform corporate balance sheets. For large retailers and brands, refunds could be substantial. For smaller businesses, they could be a lifeline. This is a correction, not a subsidy, returning funds that shouldn't have been collected. Customs faces a tight February 6th deadline to switch to electronic payments. Trade lawyers and customs brokers are racing to prepare clients for ACH. Companies must ensure ACH setup or risk refund delays. The volume and sums will stress test the new system. Glitches could cause headaches. Even after a ruling, navigating claims, amounts, and potential interest disputes will be a monumental task. While $150 billion in refunds grabs headlines, your biggest impact could be lower prices. Tariffs are taxes on imports, passed down the supply chain. If tariffs are removed, that chain can run in reverse, from importer to wholesaler to retailer to you. Import costs fall, creating room for prices to drop. Effects vary by product. Items with heavy import content, smartphones and TVs, clothing and shoes, furniture and home goods, may see the biggest changes. In many of these, tariffs were a substantial part of final cost. A 15% cost cut at the port can translate into noticeable savings. Not every price falls overnight. Some firms may bolster profits or reinvest. Others will hire or improve stores. Competitive pressure should pass at least some savings on, with timing faster for fast-moving goods and slower for durables as old inventory clears. Since April 2025, job growth stagnated, with trade-exposed sectors losing ground. Manufacturing alone reportedly shed about 70,000 jobs. If tariffs fall, cost relief could spur production and rehiring, with logistics and distribution benefiting as goods flow. Protected industries like steel and certain specialized manufacturing could face renewed competition. Net effects hinge on gains outweighing losses. Freer trade tends to lift overall efficiency despite short-term dislocations. Expect shifts toward logistics, retail, and globally integrated manufacturing, with transitions critical for workers. If the court upholds IEEPA tariffs, high import taxes continue and refund hopes vanish. That would cement expansive executive leverage in trade and keep sudden tariff risk in the landscape. Officials signal Plan B via other authorities, including provisions of the Trade Act of 1962, indicating tariffs may persist via alternative tools, leading to new legal and economic battles. The decision will set off a chain of events. Being prepared helps you navigate. Consumers, watch electronics, apparel, shoes, and home goods for early discounts. Compare across stores as competition heats up. Businesses, contact your broker or trade counsel. Ensure ACH setup with customs before February 6th. Reassess supply chain and pricing. Investors, import-heavy retailers, consumer discretionary, and global tech supply chains may get a tailwind if tariffs fall. Tariff-protected sectors like steel and aluminum could face pressure, rebalance exposure, and prepare for volatility. Clearer trade rules can lift confidence. The verdict is the beginning. The real impact arrives as prices, jobs, and investments adjust. We'll track the ruling and how it hits your wallet, the job market, and markets in the weeks ahead.